Hey everyone, how are you doing? So yeah, I'm doing a lot of recording today. That's how I'm doing. Whew. Okay, I actually have a bylaws committee meeting coming up very soon, so this can't be too long. And it's a new subject I am tackling. So periodically, as I find information, or as right now I'm getting almost everything, though I did find some other information from Ballot Access News. If you don't know what that is, it's a newsletter put out by Richard Winger, who is an amazing resource on ballot issues. He also runs the website type blog Ballot Access News, and I'd really encourage you to check that out. And I think it's like $15 a year for the newspaper or paper subscription. It supports him. I'm very happy to do it. But I like delving into these because when you talk about things and you have a discussion about them, I think it sinks in more. So that'll help because I'm really trying to absorb this information. And I think just in general, forget, just libertarians. Obviously, we're very concerned about this. But I think it should be of interest to everyone, and they just don't know it should be of interest to them. It's cold down here because they just don't know. There's the myth that little Johnny could grow up to be president, right? No. We know that's a pie-in-the-sky dream, but it's even more a pie-in-the-sky dream when you realize how heavily censored the ballot is. The absolutely corrupt duopoly. It just then incenses me even more when people do and this happens every election, doesn't it? You can vote your cute little third party next time. This is the most important election of our lives. It's just funny how everyone seems to be that. But what you're doing is rewarding the mob. When are you going to break free? So, introductory rant over. If you like the third party work that I do and the libertarian perspective, etc., the history, please consider supporting my work at patreon.com/Pink Flame of Liberty. It would mean a great deal to me. And please make sure you're subscribed to this channel and give this video a like. Without further ado, let's get started. So again, I am drawing primarily, and it's not from the entire issue. We might do another show on this. And as I always say, this is participatory. I can see your comments, so please comment if you have things to add. I always prefer interacting with people because I hear myself talk way too much. So I'm going by the April 1st Ballot Access News. And I'm reading this thing and just getting incensed. So the first one, let me take a look. I've got my notes here because there's no way I can memorize this. So the first issue is an opinion in the Sixth Circuit for a Michigan case. The hold on one second. I don't even understand what my notes. I know there's an issue with the petitions. The opinion invalidated Michigan's petition requirement for statewide independent candidates, which was 30,000 signatures due July 19th of an election year. Now, the basis for the invalidation of these petitions is it's basically an impossibility that no presidential petition has ever successfully completed it. And the other issue is the deadline, because the deadline for it requires independent candidates to have completed their petition before the major parties nominate. And Richard Winger noted that similar issues are going on in Tennessee, so this could be a precedent. Now, this isn't definite yet, as long as it stands, because Michigan will probably ask for a rehearing. these requirements, they're cray-cray. But here's the one that's really got me, and that is fascinating. It's in Montana. There's legislation that passed out of committee. It's quite likely to become law. Now, it doesn't ease the 5,000 signature petition requirement or an unequal county distribution. For those of you who don't have that, we have that for, I think it's for Colorado constitutional amendments in Colorado, where you have to get a certain percentage of your signatures from each Senate district. And that makes it very difficult in Colorado in the rural areas because, you know, where you could go door to door, heavily populated, and get a ton of signatures. In the rural areas, the houses are miles apart sometimes, and people don't congregate like at grocery stores and the like. So here's the background for this law, the issues that this law is attempting to remediate. And it all has to do with the Democratic Party and the Green Party. We're so used to issues being with the Republicans and the Libertarians. So now we've got one with the Democrats and the Greens. The Democrats screw the Greens just as much as the Republicans screw us. So the Greens were not a ballot qualified party in 2018, so they collected signatures. The Democrats successfully challenged that they had enough signatures so they weren't on the ballot in 2018. I do not know the basis of the challenge, how they threw out any. That information wasn't included, and I couldn't find it in my research. So along comes 2020, and the Greens obviously wanted to be on the ballot, but they figured they would fail again. And you know, it's a lot of resources to get those signatures when you are a minor party. So the Republicans, obviously feeling that the Greens would hurt the Democrats, which then helps the Republicans, basically petitioned for them. And they got enough signatures. But the Democrats once again successfully challenged. And the new law would change the situation in which that was able to happen. And what the new law does is it allows substantial compliance with the signature requirement. It used to be like, say, on your voter registration, you used your middle name and signed with your middle name. On the petition, because, you know, you might have registered to vote years ago, and, you know, sometimes your style of how you use your name changes. I mean, I've got a ton of stuff that doesn't have my middle name, and now I consistently use my middle name. So if they differed at all, like if you used your middle name in one and not in the other, your petition, the signature would be invalidated. The new law says as long as it's in substantial compliance, it would still be fine. Also, what the Democrats did to invalidate this petition is they sent out activists to door knock at the people who signed the petition, asking them to withdraw their signature. And they did this 3 months after the deadline to submit signatures. So there was no chance to cure because the deadline had passed, yet they were asking people to withdraw their signatures after the deadline. So the new law would make the withdrawal deadline the same or concurrent with the deadline to turn in for signatures. Also, the new bill changes the language, and we're going to get into this language thing a bit in depth because I somewhat disagree with the way Richard Winger characterized some of the language. Because when I was reading that piece in here, I'm like, I really want to read the actual decision. So I pulled up the Montana Supreme Court decision and went through it. You know, I've got a bunch of stuff highlighted. And I think he mischaracterized it, but we'll go over that. So this new bill would change the language from a party may present a petition to request qualification to any elector may present a petition. Because the old law said let me read exactly what he said, because I want to show how I potentially disagree. Okay, so Richard Winger put down, the old law says that, quote, a party, end quote, may present the petition. The state Supreme Court had construed the old law to mean that the Green Party 2020 petition was invalid because it had been circulated and submitted by people who were not real Greens. I don't think that's necessarily incorrect, but it's incomplete. And we'll get into that, but I wanted to read exactly what he said. But he notes that in Michigan, there's no public record of party registration. So unless a person declared what party they registered with, you would have no way of knowing. And on the petition itself, it wasn't required that the political party for whom the petition was being circulated reserve their name in advance, and also or like have the officers of the particular party on the petition. So Richard Winger characterized this as an arbitrary decision. I don't agree with that characterization. Let me make sure I am Let's find this here. Here. When the Montana Supreme Court removed the Green Party, its decision was arbitrary. It wasn't, though. Neither side had presented any arguments about this issue. That is true. That doesn't mean their decision was arbitrary. And the lower court had not even mentioned it. It could mean it was out of order, but it doesn't mean it was arbitrary. Thus, there was no evidence in the lawsuit to establish the motivations of the petitioners or their partisan feelings. Yes and no. The decision was based on the court's belief about the motivation of the circulators. Not exactly. And then Richard says, but petitions should never be invalidated just because an election official or a court doesn't like the motivation of the people circulating the petition. Absolutely agree there. But I'll get into the actual case so you can see where I differ. Now, this bill has to go through the House, I believe. It's already passed the Senate. Now, here's what makes me so sick. It passed the Senate on strictly party lines. So all of the Republicans voted yes, and all the Democrats voted no. Why? We know why. You could bet your ass that if this was about libertarians, the votes would have been flipped. So, let's look at the case itself, because the dissenting opinion is really interesting as well, and it gives some more information here. So at the district court level, the district court concluded that the petition seeking to qualify the Montana Green Party to hold a primary election to select its nominees for office and to obtain ballot access for those nominees failed to meet the requirements of, and it gives the statute. Okay, so here's the background. In mid-February, and here's where the Green Party made a mistake, the leadership of the Green Party said that they were not involved in the petition effort and they disclaimed the petition. And at that time, people did not know who actually organized and funded that petition. So, while not knowing who organized it, and this is before the signature deadline, the Democratic Party organized a counter effort, reaching out to petition signers and encouraging them to withdraw their signatures because it was not known who was organizing and funding the effort. And about 150 signers asked for their names to be removed from the petition. But on March 6th, the secretary completed the tabulation and announced that the Montana Green Party was qualified for the primary election through the petition process. So it was a successful petition. And shortly before the primary election, the Montana Green Party leadership publicly disclaimed the candidates running under its banner in the primary. I would love more information on that. Okay. On March 24th, so a couple weeks after the signature deadline, news reports reported that the petition had been sponsored and organized by the Montana Republican Party. They contracted with a petition firm. And the expenditure for the petition firm was credited as an in-kind contribution to Montanans for Conservation on their financial disclosures. Montanans for Conservation filed as an independent committee rather than as a minor party qualification committee, which was required in the statutes. It did not change its status to a minor party qualification committee until March 23rd. And the sole financial contributors to Montanans for Conservation was the Republican Party, the Montana Republican Party. So after it was found out who actually was funding the petition, the Montana Democratic Party, redoubled its efforts to get people to withdraw their signatures by educating them on who funded the petition effort. So hundreds of petition signers then requested to withdraw their signatures between March 6th and June 2nd, which was the day of the primary election. And a lot of the withdrawal requests were done electronically because of the whole COVID thing. But the Secretary of State declined to honor any withdrawal request that came after March 6th, the deadline to submit signatures. Okay, you got the fact pattern? But I want to know who was running as the Green Party candidates since the Green Party disclaimed the candidates. Was it Republicans? The plot thickens. Everything is just so dirty. Now, here's where I start to disagree with Mr. Winger. The law says not a party, like he says. Here's the entire law. A political party that does not qualify to hold a primary election under subsection 1 may qualify to nominate its candidates by primary election by presenting a petition and so on and so forth. So it wasn't just a party may present a petition. It was a political party may present a petition to nominate its candidates. So the decision that it wasn't Greens isn't quite like so weird if it just said a party. So he wasn't wrong. It did say a party, but it said more than that. So I think his recitation was incomplete. So the district court found that the Montana Republican Party sponsored the petition and that the evidence before the court demonstrated that the Montana Green Party disavowed the signature gathering process and has also disavowed the persons filing under the Green Party banner as not being true Green Party members or adherents. Okay, that seems to be a little different from what Richard said, because Richard said there was no evidence in the lawsuit to establish the motivations of the petitioners or their partisan feelings. This is evidence. If the Greens were disavowing it, that's evidence, isn't it? I think so. And it said the evidence before the court. And continuing. And all of the parties involved here, at least until later on, the Greens weren't even involved in the lawsuit. It was the Republicans and the Democrats and some of the people who, the Republicans filed as amici. They filed an amicus curiae breach. It was the Democrats and the Secretary of State. And the Green Party didn't get involved at all. I'm unclear as to, they got involved in an ancillary matter. I'm not even going to get into that. Okay, here. Now, it's interesting that the court, at least in its dicta, which is, you know, just commentary on the decision, though this is the order, said that if any party, any person other than the political party itself presented a petition, so it says, if the statute allowed petitions to be presented to election administrators and then accepted by the Secretary of State without the subject minor party's participation or endorsement of the petition seeking to nominate that party's candidates through the primary process, serious concerns would be raised about violations of the associational rights of minor parties. And I agree, particularly since in this case, the candidates that ran under the Green Party banner were disavowed by the Green Party itself. So that is a concern. So is that now, once again, arbitrary? It's not an arbitrary decision. There's a rationale there. Okay, continue. The Montana Green Party did not authorize this, okay? We have established that. So now we're on the conclusion that the Secretary of State must invalidate. Okay. Now, the dissenting opinion is where I think Richard Winger's getting some of his opinions. Justice Beth Baker was the dissenter, but there was also Justice Jim Rice joined in. So there were 2 dissenters and 4 justices that were in the majority. Okay, let me continue here. So it says that the theory of the Democratic Party was that because Montana's for Conservation was a shell group of the Republican Party, and it wasn't disclosed that way, individuals who signed the petition who would reasonably believe it was sponsored by the Green Party were misled and therefore had the right to withdraw even if it was after the deadline. And even if the district court came to that conclusion by an incorrect means, that it was proper, well, this is what the majority said, that the majority said that it was proper for the appellate court to affirm the decision if the decision was right, even if it was obtained by improper reasoning. So, a complaint often has introductory remarks and then it pleads certain facts. The introductory remarks aren't really the issues pled. It's just background. And that's where I think Richard Winger is getting that there was no evidence presented. But that isn't what the majority said. So the dissenting opinion said, seizing on the complaint's introductory remark that the Montana Green Party had absolutely nothing to do with the petition, the court hopscotches the pleaded claims to its prayer for relief, seeking a declaration that it failed to meet the requirements of the statute. The complaint, though, alleges this: the petition fails to meet the requirements of section, and it cites the section, because it doesn't contain the requisite number of valid signatures from at least 34 House districts. It says the basis on which the court invalidates the petition, so the appellate court, was not presented to the district court. And this is where Richard is getting it, that it wasn't pled that the Montana Green Party had nothing to do with the petition. But is that in fact the case? Or is that the background for it saying it does not contain the requisite number of valid signatures because signatures obtained through fraud aren't valid? You know, I just have so many questions here. A very interesting discussion gets into the fact, though, of whether the Secretary of State was incorrect in saying March 6th was the withdrawal deadline when the statute itself didn't say that. And it gives a very logical argument as to when that is. I'm not really going to get into that. The new law would change that, and I think that's a common sense change. But here, which was interesting, it says the court reaches to find case law in support of the ostensible proposition that we may go beyond the issues the parties presented if there's good reason to do so. And the dissenter says, in my view, it is unwise to perpetuate a theory that courts should take up an issue without affording the parties due process by giving them a chance to be heard on it. I absolutely agree. If it was not pled, but we're now talking about more of a procedural issue and like a notice issue and fair dealing issue, I think. If it wasn't really part of the actual pleadings in the lower court, then it shouldn't be raised by the higher court. An appellate court is just a review court. And allegedly, this idea that the Green Party had nothing to do with the petition was not pled. It was just an introductory remark. But introductory remarks are usually, they're there to give the history underlining the things that were actually pled, and they did plead it wasn't valid signatures. Why weren't they valid? Because the voters were misled. So I'm just not convinced here of the dissent or of Richard Winger. I'm not saying I agree with these laws. I'm just viewing the fact pattern, that's all. You know, whether or not the law is bullshit is an entirely different matter. It says, were we to consider the fraud argument on the merits, and I understand what they're saying, even though that was underlying their claim that they weren't valid signatures, fraud is a very specific thing and it should have been specifically pled, but it wasn't entirely arbitrary. It said, were we to consider the fraud argument on its merits, it would be also necessary to consider the amicus Montana Republican Party's contention that the district court's process improperly failed to allow presentation of an argument they argued would rebut the plaintiff's claims. Okay, now that's an interesting thing, though. I wonder why the district court didn't allow the presentation. If they didn't allow the presentation because fraud wasn't being alleged and wasn't being considered at all, then I understand this court saying you can't consider it if it was improperly excluded on that basis. But it seems like that might be what happened, but without having more information, it's so hard for me to tell. Then that would make sense. But it's still not entirely arbitrary. I think perhaps Richard and I are using arbitrary differently. Like, they didn't just pull it out of a hat. There was allegations to that extent. They didn't make it up by guessing, well, we think the motivations were such and such. And the Montana Green Party was very public in its disavowal. So, but maybe Richard means it was procedurally arbitrary. I could get on board with that. Okay, it says the district court rightly observed that the statutes do not expressly provide a process by which an individual may withdraw his or her signature. And this is dealing with whether or not the electronic withdrawals were valid. The district court held that they were valid because they had signed a Uniform Electronic Transmissions Act. And I forgot, I was just talking about this, I believe, with someone in Colorado who was talking about electronic signatures and how a federal law bound states that they had to accept it. And I read it, and that's not what it said. But anyway, this would seem to support, like the district court seemed to support that. It's like, well, you passed the Uniform Electronic Transactions Act, and because you didn't explicitly disallow electronic signatures, then you allowed them. And this dissenting opinion says that is not correct. And they get into some details as to why that's not correct. So, yeah, I just wanted to make sure my last highlight. So I thought the dissent was very well done too. So, yeah, this is a weird case. And even though this was ostensibly on behalf of the Green Party wanted nothing to do with it. So on general equity grounds, without even commenting at all about the law, I think it's right that it got thrown out, because it was the Republicans playing games and trying to be two political parties, trying to run their real candidate and then have shell candidates to dilute, in their view, the Democrat vote. And that's just dirty. Like, they have dirty hands. I won't cry a river. Okay, next one. We're only going to, I think, deal with one more, but that one was fascinating to me. Let me find, oh no, maybe two more. Let's see here. Okay, yeah, two more. Iowa. New legislation in Iowa. And it says now, Iowa prior to 2019 had really easy ballot access laws. Since 2019, it has the most severe ballot access laws it ever had. So it's, you know, extremes. It swung the extremes. So now for a statewide office, the petition requirements went from 1,500 to 3,500. And for U.S. House, from 375 to at least 1,726, and added a county distribution requirement. So for statewide office, you have to get at least 100 signatures from each of the 19 counties. For House, you have to get 47 signatures from each of at least half of the counties in that district. And this is the first state to ever do this for those offices. And it passed under strictly partisan lines. You might wonder why. Well, here's why. And the partisan lines were the Republicans supporting these severe laws and the Democrats opposing them. Why? In the 2020 U.S. House race in the 3rd District of Iowa, the Libertarians beat the spread. Democrat votes, 219,205. Republican votes, 212,997. Libertarian votes, 15,361. More than double the spread. And it's not entirely unreasonable to think that if there was not a Libertarian candidate, that half or less of those who voted might have voted for the Republican. I mean, that's not entirely unreasonable, but they're not entitled to those votes. But so what did they do? To punish those people. How dare you not vote for the Republican? How dare you? That's what they did. Now, Richard Winger noticed that county distributions have been shown to be unconstitutional in other cases. So this likely will get struck down. And also in 2019, Iowa moved the deadline for the petitions from August to March, and the Libertarian Party is presently suing over that move. Okay, so now here's the last one. I wrote down North Carolina, but I think it's South Carolina. It's South Carolina. I don't know why I wrote down North Carolina. So South Carolina instituted filing fees for minor parties, or any parties, but it's the minor parties that do not nominate by primary, but instead nominate by convention. They used to only require them, from what I understood, for the parties that nominate by primary. And at first I thought, oh, that somewhat makes sense because primaries are on the public dime and they should be able to recoup some of that cost. Though later it turns out I was really wrong-headed in thinking that, but that's what I originally thought. But check out this filing fee. It's 1% of the salary of the office sought. And at first that doesn't sound so bad because, you know, what are we talking? Maybe a couple $1,000s. I mean, it's bad, but okay. But no, that's not it. It's 1% of the salary for the entire term. So the $160,000 or so per year for Senate times 6, because it's a 6-year term. So the filing fee for Senate is $10,440, and for House, $3,480. That is a lot of money, and there is no provision for indigency, no like alternate petitions in lieu of a fee. Now, in an unreported case, but a South Carolina case, I want to try to find this unreported case. It was ruled, and Richard must have a copy of it, as that's how he knows about it, because he said he guesses the legislatures didn't even know about this unreported case. But in that case, it was ruled unconstitutional to have filing fees unless the purpose of it was to prevent ballot crowding. But if you're nominating by convention, there's no ballot at all to crowd. So there's absolutely no purpose. And that same decision explicitly said filing fees cannot be levied to defray expenses. But in passing this law, the legislature explicitly said the reason for the fees is to defray expenses. And that's where Richard Ringer said they're probably not aware of this unreported decision. And of course, the deadline, the filing fees have to be paid in May. So that is all I have for you today. I just wanted to get my feet wet in this. We have some others we can go over. I'm not sure how important they will be. So there's some things on Georgia, Arkansas, and then some updates on the Supreme Court. So I'll read them and see if it's something interesting enough to bring to your attention. But that is it for now, and I am on my way to a bylaws committee meeting. Just one more reminder again, if you enjoy this, please check out my Patreon. Other than that, I hope you have an awesome evening. Bye-bye.
You gotta take what you're given, that's how we live it. Don't be mad at the system, it's simply how we've existed. I hear a lot of people talking like they politicians or choose to be an accountant because it's safe in the business, not because they want to